My name is Amanda Smith. I am a partner here at Tully Rinckey. Regularly, we handle a lot of plaintiffs' employment matters, so discrimination and the things that we'll go over today. We also advise companies. This information is very good to know because if you're an employer, what kind of rules or what things that they should be on the lookout for that would be a violation of the New York human rights law. So I'll go into that a little bit, as well as other instances where this law might apply outside of employment, things that you might not necessarily immediately think of, like housing, public accommodations, education setting. So what we're going to go over today is Article 15 of the New York State Executive Law. It's Section 290 to 301. Collectively, this is going to be referred to as the New York State Human Rights Law. I'm going to just, for the sake of brevity today, refer to it as the New York State Human Rights Law or the Human Rights Law. We're going to focus today solely on the state aspect. I might compare it throughout today to federal law, or there is also a New York City human rights law, which has different rules and is a little bit broader in some respects. So I might, throughout today, notice that there's certain differences between the two, or if this is more comparable to one or the other. But as far as what we'll go over today, Article 15, the New York State Human Rights Law applies to all employers across New York State. So people in New York City and people in Buffalo and Syracuse and any small town in between. This law prohibits discrimination in several areas, and I'll list those out next. It also prohibits retaliation based on any type of exercise of rights to raise discrimination. So whether that's an internal complaint with your company, or whether that's something outside with a court or a state agency. It has a vast coverage well beyond any type of federal law, and it's very liberally construed in terms of what qualifies under each type of protected bases. It also provides potential remedies. New York State provides remedies including orders to stop the discriminatory practices, a reinstatement if an employee has been terminated, potential back pay, compensatory damages without a cap, in comparison with the federal law, and in some cases, civil fines and penalties. If, for instance, the Division of Human Rights or a court orders some action to be taken by an employer and there is a willful failure to comply, that could trigger potential fines or penalties. So it is very important for companies, if they do receive orders like that they do track and they maybe consult with an attorney, or we advise clients that there could be risks if they don't follow through on something. Now, I touched on it a little bit. The purpose of Article 15, New York State has really mandated it that they are going to fight discrimination because it really does erode a sense of democratic principles. New York State has really put forward this idea that individuals need to be protected, and the state's job is to look out for them. So every aspect of Article 15 is to protect the individuals and things that we have seen in history that they're vulnerable to be subjected to. And so things that the goals of Article 15 is to target is to prevent that, make it a fair place. If someone is trying to obtain a rental property, or they're trying to get a loan, or they're trying to just do their job, that they're able to have the same opportunities as the next person, and to eliminate any type of potential for discrimination, for retaliation, for just being exactly who you are. In 2019, the human rights law was amended, and where New York State kind of liberally construed the protections as it was in 2019, it was very clear that the courts were instructed to construe the statute liberally. And it was very clear that they did not want comparisons with any type of comparable federal law. So if federal law has similar language and it's interpreted this way, New York State was very clear that that's not to be the case here, that the courts are supposed to be going beyond what may be a common law interpretation. The other aspect in 2019 that Article 15 was expanded upon was who it applies to. So these employment protections and in respect to education protections apply to both public and private institutions and employers. There's also no limit on how many employers or employees an employer has to have these protections. So before it was 4 or more employees. Now you just have to have an employee, and there are protections under this law for those individuals. It also expanded on who qualifies as an employee and who qualifies as protections under this law beyond just a normal employee. What is also different for Article 15 or the New York State human rights law in comparison with federal law is the burden for harassment claims. So if you practice regularly discrimination claims in federal or private sector cases, you'll know in federal court or any type of claim you have for a federal employee, the burden for harassment is a severe and pervasive environment. In terms of New York State, the burden is much, much lower, and they have equivalent to what was more broad or the lower burden for the New York City human rights law, which I would say is treated less well or treated not as great as the other person. Now, that is definitely a much lower bar. It opens up for things that previously were considered like petty slights or just workplace issues or normal, drama, something like that you might have seen from a court or an analysis. So nowadays, when you're having some sort of discrimination or retaliation claim with New York State, anything is possible to bring. There's not a high burden on an employee or on a student or an applicant to assert these kinds of rights. And finally, it's important to note before an employer might have had a defense where the employee never sought an internal complaint, never raised these concerns to them before, despite being aware of or having some sort of internal complaint process. That no longer matters. That's not going to be a defense that employers can use against an employee, say, taking it outside of the company or not filing something internally with the school before they proceed with some sort of action in court or with the Division of Human Rights. So the protected categories under the New York State human rights law are going to be quite a few. As you can see on the screen, I'll read them off. I know everybody received this list here. It applies for any type of discrimination claim. So you can claim discrimination based on race, creed, which goes beyond just the normal federal religion definition, color, national origin, sexual orientation, gender identity, which also includes gender expression, military status, which is a little different, includes in New York State, if you've served like in the New York State militia versus the National Guard versus if you served like the Department of Army. Those kinds of things are something to think about when you're analyzing where to file a military status discrimination complaint. But that is covered here. It goes beyond just the federal laws. You can also bring a claim about sex discrimination, disability, age, which for New York State is 18 or older, not 40 or older like federal law. Your marital status, your familial status, your source of income, and this comes to play in housing or public accommodations, prior arrests or conviction records, citizenship or immigration status. Retaliation is also covered for opposing unlawful discriminatory practices. An important point to make here is that under New York State law, it is not retaliation if you've filed or requested a reasonable accommodation. So federal law protects protected activity and considers a reasonable accommodation request as protected activity. New York State, various courts and the state has not elected to amend or clarify that reasonable accommodation is a protected activity. Also protected categories are pregnancy-related conditions and predisposed genetic characteristics. I will note, again, going back to the retaliation, what qualifies as protected activity. There is also in New York State, New York City human rights law, there is a potential where requesting a reasonable accommodation could qualify as protected activity. So briefly mentioned before, and to get in a little bit more of an overview, areas of protection for the New York State human rights law include in the employment context, in the housing context, public accommodations, the education context, that's as a student or an employee, and in credit transactions or accesses to services and facilities. Something to note, in 2024, there was an effected amendment where to bring these claims before either a court or the New York State Division of Human Rights, any claim that occurred from February 15th of 2024 to the present has a statute of limitations under the law of 3 years. That's whether it's a sexual harassment complaint, a harassment complaint, or just independent acts of discrimination. For anything that has occurred prior to February 15th of 2024, there is a 1-year statute of limitation on claims of discrimination. For claims of sexual harassment, it is the 3 years. So something to keep in mind would be if, what type of claim are you thinking to bring? Is it a sexual harassment complaint? Is it, independent acts? The only thing that has changed is from the 1 year for all claims has been expanded to the 3 years to match. So there's no difference anymore, as long as it's something that has happened after February 15th of 24. Okay, so now we're going to get into a little bit more of the meat and examples. In terms of employment discrimination claims, like I mentioned, there were amendments to the law, and it expands what is considered to be an employee or someone covered if they're going to bring a employment-based discrimination claim. You can be an employee, most definitely, but you can also bring a claim if you are a consultant or an independent contractor or other non-employees if there is discrimination or retaliation which occurs in the employer's workplace. You still have to, show that the employer has liability, that they were aware of it, that they could have taken action. All of these things still apply, but it's no longer, just if they're a contractor and something happens to them and they can't sue then the employer in which they're working on the job site or something along those lines. So there is a broader consideration of who can file such discrimination claims. And it is important to note too that there was amendments where essentially New York State is prohibiting arbitration provisions for an employee in terms of sexual harassment claims. So some employers, you enter into a contract and they prohibit or they want to have arbitration for any type of legal claim that might arise because of the employment contract. New York State has taken a very clear stance that they do not want these types of arbitration limitations on sexual harassment claims. So if an employee brings one, which is something that I recently had to deal with within the last year or so, that they can't enforce it, you could still file a Division of Human Rights complaint, or you could still take it to court. It's going to be very hard for that employer to say, that this person can't sue me. We have to go to arbitration if they're bringing a sexual harassment claim in violation of the New York State human rights law. Certain things that can be a violation or a discrimination claim is pretty broad. Independent acts of discrimination could be a refusal to hire, a preventing an employee or someone to be hired. If they terminate an employee, those are some maybe more common ones that you might see, or someone's wanting to make an issue out of a claim out of. But it also covers things like here the terms and conditions or privileges of an employment, and those are a little bit more of a broad definition as opposed to a very clear cut, this person did something wrong. So you can also bring discrimination claims in regards to if they refuse to refer an applicant for a position, if they were advertising to specific individuals, were they targeting specific persons instead of opening up to the entire public to apply? Were they soliciting employment from certain individuals? Were they limiting where they were circulating pamphlets, or making statements about the availability for a position? Now, there are exceptions in certain respects to these advertisements of positions, or preventing an applicant from being someone who's considered eligible. If there's very clear, like, bona fide reasons that someone needs to be, specifically for that position. And that's a case-by-case analysis there. But if someone, is being prevented from coming onto a job, applying for a job, if a company is improperly, advertising for select group for that position and excluding individuals, all of those things could rise to the level of a discrimination complaint. Other types of employment discrimination claims might be things where, say, an employee becomes pregnant, and the company is trying to force her to take a leave of absence. Any type of, even if you have a medical condition, if they're forcing you to take a leave of absence, if they're not affording an individual the ability to take leave, if they're forcing them to take a certain type of leave, if they're subjecting them to a fitness for duty examination, all of those kinds of things can rise to the level of a discrimination claim. Generally, harassment, which would be the collection of a bunch of things happening to the individual. And like I mentioned, it's not just severe and pervasive, it's anything. A coworker, treating them on the daily where they're ignoring them, things where in the federal system, maybe it'd be a little bit too low to be considered a violation. But in the grand scheme, the collection of all of these, slights, these interactions that could rise to the level of ongoing harassment. People have the right to be free from this type of behavior in the workplace. They have the right to seek employment. They have a right to be employed and work at an employment, a company. So if anybody's interfering with their just right to exist in that company and perform their duties, that could be a harassment claim. What also might constitute harassment in the what might also be considered discrimination in the employment context, that might not normally be considered, is anything like an apprentice training, apprentice program, on the job training programs, executive training programs. If you are being denied this training, if you're not being afforded the opportunity to elect this training, and others are, that might also fall within the realm of a discrimination complaint. If you're not being permitted to engage in other training aspects, if a company is denying you the ability to take part of a training program registered with the state, and they're saying, you're not eligible for it, and they give no reason for something like that, that could rise to the level of a discrimination claim. The other aspect for employment claims might be a retaliation claim. So in terms of retaliation, that would be if you've expressed to your employer that what they're doing is discrimination, if you've expressed to them that you're being harassed, if you've made internal complaints or just informal complaints, anything like that might qualify an employee for protections under the New York State human rights law as protected activity from which they could then sue for retaliation if things happen afterwards. So cases like this might be, someone speaks up for themselves, a client comes and they say, I've experienced XYZ, I contacted my employer, I filed this human resources complaint, they've done nothing, and now I'm terminated. Those are clear potential retaliation claims that you could bring against the employer, and potentially, depending on who is involved in the claim, who did the termination, the circumstances of the employment. It might not just be the employer. It might, there might be a claim of individual capacity as well. So outside of the employment context, the New York State human rights law also protects you in the context of housing. So this would be, generally speaking, it's illegal under the New York State human rights law for someone to discriminate against you in access to facilities or privileges of a housing complex. They refuse to give a loan or to go forward with a credit application. If they target specific individuals or prevent you from getting, advertisements for services or an offer of services, and if they refuse to give services. So this is a little bit more, this is beyond just a refusal to rent. It's a refusal to, for instance, like if you live in an apartment complex and someone, has a superintendent or an employee that maintains that apartment complex, if they are not maintaining the individual's apartment in the same way as the others, if they are in any way, if you're looking to contract with someone to do work, if they're not wanting or refusing to perform those services for you, for any of the covered protected bases, New York State human rights law does provide for a discrimination claim regarding those types of actions as well. So again, not in the employment context, in the housing context, as someone who is a renter, owns a house, is looking to rent or own a house, and you're looking for work, anything associated with that. Something to note here for housing as well is back when we were covering the protected bases, sources of income. If your source of income is, provided from the state, if, you receive income from various different things, you can't be discriminated against because of where you are getting those funds, where you're getting that income. And that comes to play in housing, as well as what we're going to discuss next, which is public accommodations. So public accommodations is the context of renting and selling and leasing. So human rights law in New York State prohibits any type of discrimination or retaliation in the context of you wanting to rent, to buy, sell, and lease any type of housing. So whether it's subleasing or you're leasing from the individual, if it's renting, if it's access to, so if it's a condo, if you're not able to access the facilities like the common pool, or you don't have access to certain services or things along those lines, like others in the area might, if they're advertising to exclude a specific group of people from being, from applying for the rent or from buying the house, those kinds of things would be violations of the New York State human rights law. Part of this as well, and what you might see is if a rental complex, an apartment building, is advertising select apartments for rent, and they provide certain furnishings, certain things within the apartments to individuals who are looking to rent or to buy, and they don't provide the same things to the same people, then that might be a potential claim of discrimination in a public accommodation or housing situation. It is also a violation of the law to discriminate against someone from having any type of public assisted housing accommodations. So this is where, again, the source of income comes into play as a potential basis for discrimination. You also cannot seek, or an individual cannot ask you can't ask the person what their race or their national origin or their gender is in the context of a rental agreement or buying a house or something for those contexts. You can't do it orally, and you can't do it in writing. Nowadays, you're probably dealing more with the oral asking as opposed to the written, but something to keep in mind that you need to watch yourself and asking these kinds of things, and any type of a buyer, or if an employer owns a lot of housing facilities and they're looking to rent, it's something that anyone who is in charge of these kind of processes is aware of, that you can't do that. We treat everybody the same way, and it could be a potential violation of New York State law if you're even remotely approaching these lines. One of the final categories for the New York State human rights law is the education context. So aside from doing a lot of the employment claims, I also handle education claims. And it's something that I've been recently getting a lot more consultations regarding it in the education context. The New York State human rights law applies to public and private institutions. So whether we're talking about, excuse me, Cornell or the State University of New York in Buffalo, or New York University, whatever school we're talking about in a college setting, or even graduate, undergraduate, elementary school to high school, the New York State human rights law applies and protects students from discrimination. This can be anything from a student being subjected to discrimination by their peers, by somebody in the program, by another schoolmate. They report it to the school, and the school takes no action. They don't investigate, or they don't take any type of remedial action, which would be reasonable to assess and prevent the conduct from occurring again. These kinds of claims can arise, like I said, at any age. It's important, for parents to be advised. These would be claims they would be pursuing for their children if they're under the age of 18. But it is something I think that is being highlighted in the current atmosphere of what we're dealing with the last few years here, of college students, and the claims about race and religion and national origin, potential differences in how they're being treated. So I've been seeing a large uptick of these kinds of claims. They can bring them. It is a violation of the New York State human rights law, and they have the same potential processes that they can pursue those claims as someone who is, an employee and they're suing their employer. And so we'll go over those kinds of options in a little bit, but it is something that to keep in mind. This can be also if someone applies to a college and they are rejected as an applicant, if they don't even look at their application, if they refuse to accommodate them, if they've asked for specific accommodations, they've been denied. And then they've proceeded to get, bad grades. The teacher is not performing properly. They're preventing access to the classroom, or ultimately they might be, kicked out of school. They might be suspended. They might be, otherwise punished. All of those things could rise to a claim in violation of the New York State human rights law. Now, the final category here of what New York State human rights law prevents discrimination is in the context of seeking credit. So this is in the context of seeking credit, or a personal loan, a housing loan, any type of loan application, a car loan. you are protected in regards to, if you're applying for a loan for construction, if you're applying for a home equity loan, if you're applying for any type of repairs or cover, or even just buying a house, anything is what New York State human rights law protects. So this is in terms of the rates, terms, or conditions of the loan that's being offered. If it's in regards to granting, denying, extending loan terms, or renewing a loan, the creditor, the bank, or whoever you're applying for the credit loan process, if they advocate for like family planning, if they ask someone if they have the ability to reproduce, if they advocate for like birth control or some sort of context surrounding that, that's a violation of the New York State human rights law. If they, in the course of your credit application, the individual reviewing the loan refuses to consider certain types of income. So this is where, again, sources of income is a protected category. You could possibly have a discrimination claim if that is used in the course of denying or trying to deny your credit application or loan application. This also is not just in regards to the person making the loan application, but also if, say, it's a corporation making a loan application and there is discrimination potentially because of the person themselves, a family member, a stockholder, a director, an employee, or an officer of the applicant who is making the loan application. So it is a bit broader, where it's not just, if it's because of the specific characteristics of the applicant, but it could also be because of their, immediate, relevant members concerning the applicant and who's making the request. So the options someone has in a discrimination complaint. You can either take the claim to the local state court. So this would be based upon where the individual is located. You file with the local court, or you can file it with the New York State Division of Human Rights. So DHR for short, insanity. The deadlines to initiate either complaint, whether it's in state court or with the Division of Human Rights, is going to be the same. So it's going to be for anything after February 15th, 2024 to the present. That's 3 years for any claim. Before then, it's going to be 1 year for any type of discrimination claim or retaliation claim, 3 years for the sexual harassment claims. You can choose an either or. So state court is everything that state court entails, filing a complaint, service of process, answers, motion practices, a potential trial. You're going through discovery, normal rules of civil procedure are going to apply. You're going to have the court filing fees and normal processes there. You're going to be assigned to a state court judge, someone who might not just oversee specific discrimination or retaliation claims, but might see, everything under the sun, depending on the court, the county you're filing within. If you are regularly practicing in that county, and you're aware of the judges, you know how they rule, you might have a better handle on maybe what you want to advise a client to do or which avenue to proceed with. So state court is your one option. Your other option would be the New York State Division of Human Rights. Now, the New York State Division of Human Rights is set up solely for violations of the New York State human rights law. So they are going to be looking at whether or not these specific statutes are being violated. They might pull from, the case law from the court systems analyzing this, but they also will pull from the division administrative judges analyzing these cases. It's going to be more of an administrative process initially. So first you would file a complaint with the division. They would process it, send notice and a copy of the complaint to the employer or whoever you're filing it against, they would ask them for a response. They would get a response. You as a complainant or the complainant filing, they would get the ability to review that response and then submit a rebuttal and any other additional evidence that they have. So the process, the division says that, it's supposed to be done within a handful of, 2 months. That processing time has definitely been delayed. As of recently, has been a huge influx of these kinds of cases. So I would prepare, if you go down the Division of Human Rights process, it might take a little bit longer. The timeline might match up to what we normally think of for court actions. So advising clients on how long it could take, it's definitely not as advertised on the Division of Human Rights website. The initial processing might be faster. You're going to be sitting around and waiting a while for any type of probable cause decision. So rewinding a little bit, after that initial exchange of the complaint and response, it'll eventually be assigned to an investigator at the division. They will investigate. However, they foresee that to be the best way. They will potentially ask for more information. They may conduct what's called a fact-finding conference, which the investigator will ask relevant witnesses. They'll ask the complainant, the respondent, if there's specific management officials, if there are witnesses that a complainant identifies as supporting of their case. They will go through and they might ask for them to be produced at a specific day and time. As the complainant, they're going to have the ability to sit in on all of that questioning. If the investigator permits an attorney to accompany them, it depends on the investigator whether they let us ask questions or not. They might let you ask questions at the end. They may let you make a little statement, in support of your client, whether it's the complainant or the respondent, and they'll, permit something to that extent. Usually they do not permit us to speak for our clients in these fact-finding conferences, short of making some sort of closing remark. If there is a fact-finding conference, typically I'm taking notes, on what is discussed, who says what, and afterwards, normally if they don't let you make an oral closing or make some sort of point at the end of the conference, they will let you submit some sort of closing statement within a week or two after the fact-finding conference. So that would be the opportunity where you'd have to be able to say this person said this and make sure that the investigator is tracking those kinds of things, create that written record for in the event that it does continue before an administrative judge. So after you have some sort of a fact-finding conference or the investigator asks for more information or just wants to interview your client or a witness, they may foresee that it's beneficial for both sides to sit down in some sort of settlement discussion. So whether that's led by the investigator or they recommend that you sit down with the other side and try to discuss settlement, or they try to facilitate settlement where they take offers back and forth. I have seen investigators try to do that, something that they think could be quickly or should be easily resolved. Assuming there is no resolution, assuming the investigation, is complete, you'll get what's called a probable cause finding at the end. Probable cause, it varies in length depending on the investigator, but essentially it's the investigator saying more than likely than not, there was a question of discrimination or retaliation. And it's the division then referring you to a hearing before an administrative judge at the division. So there's nothing you have to file. If you get a probable cause finding, you go straight to, getting an assignment of an administrative judge. Right now, we've been seeing, I would say, somewhere between eight months to a year for an administrative judge to be assigned for a hearing. You would have the ability to foil a copy of the record, whatever the investigation record has been created, and you'd be able to use that as well as, obviously get to a hearing. It's the same kind of context of a trial. You'd be able to call witnesses, cross-examination, examine your own witnesses, present the evidence to show that there was discrimination or retaliation. So the probable cause finding is really the first hurdle. The second is you're still going to have to prove the case for the client if there was discrimination or retaliation that had occurred. It is public. They are administrative law judges. They are not state court judges. So public, anybody could attend the hearing. Most of them are still virtual these days. I think in the state context, you're having a lot more in-person interactions. But for purposes of the division, they are really still focusing in on the virtual aspect. Before you get to a hearing, they may also push for a settlement conference with an administrative judge, which would be a different judge than the one that's assigned to ultimately litigate the case. So it's a process. Again, I would compare it in length. It's currently kind of running the same time frame as taking it to state court. So really it's an analysis what might benefit the client better in terms of costs, in terms of the judges that they may be assigned in state court. If you have faith of them, if you aren't aware of how they will rule, all of those might factor in on what you choose ultimately to recommend or what you talk to the client about. Cost wise, obviously state court might also be more costly for a client for representation. But I think other than that, that would conclude the CLE and what we've prepared. So I think there might be some questions. Okay, so one question I have so far is the source of income discrimination in housing new? It was added as part of the 2019 amendments. So it is something that has been covered since 2019. So it's something to flag. It is for anyone who is offering, a lease, offering rental properties. They can't discriminate against someone because they say they're paying with a voucher from the state. Someone asked a question, could this potentially apply to a private summer camp for children, but there's a child with a disability? It could. I believe New York state law or federal law might apply there. You're talking about if they're being maybe denied specific access or they don't have certain required facilities. If they're certain things might be more federal law, where like say they don't have a ramp and they're in a wheelchair, those things might still apply. As far as New York State, I would say it could possibly apply to any type of summer camp, anybody offering certain types of services to children or to adults. What are the rules around a former employee who tries to file a discrimination complaint against an employer for alleged previous discrimination? You don't have to be a current employee to file a discrimination complaint. So if it's someone, say they're terminated or they've been on, if they're still technically employed, but maybe they've been on some sort of short-term disability or long-term disability, so long as their claim could fall within those statute of limitations, they could have a potential viable discrimination complaint. So I think depending on the length of time, what we're talking about, I think that would be the first kind of review would be, okay, when are they claiming something has happened? And that might remove some of their claims, some of the fear of what, that might result from if they were to pursue some sort of lawsuit, or what you're really looking at in terms of, advising clients, the fear of penalty or issue. But anybody can file a discrimination complaint. And this applies to if you have applied for a position and you've never actually been an employee. That could also result in some sort of possible viable legal claim under New York state law. That might be all of the questions that we have. We do this on a regular basis concerning employment law, concerning education contexts, Children has definitely been something more recently we've seen. There are other laws that apply in the education context. That might be worth its own CLE, but I can say it's something that I would be on the lookout for as an attorney. I've been getting more questions in that kind of context, especially from college students. So it's something to keep an eye out for, understand that they might not just have internal processes that they can pursue, but have this state law that does protect them and offers them an opportunity to pursue claims against the school, against teachers, professors, or other students. And it's something that is a valuable resource for those individuals because it takes it out of the context, just like, it's the concept of, the fox watching the hen house. Do you just want the college to handle something, or do you want, an outside kind of watchdog? So that's what the human rights law has really set up, is that access for someone to take it outside of dealing internally and handling it much like they would in the employment context. So I think that that's all that we have then, if there's no other questions. We're always available as practitioners if you have other questions or things that they come up. Brittany has put up our contact on the screen. I'm happy to help or talk to anybody if they have a unique case or something crazy comes up and they want to run it by someone else. We're definitely here to help. If you experience it yourself or you have family members, this is a good resource to have for people to know their rights. So I think with that, I believe we're done.